the general principle in relation to the recovery of costs is that an award of costs is to compensate for expenses that have been suffered by the winning party. It isn't to reward the winning party, nor is it to punish the losing party. And that is certainly the case if costs are being assessed on the standard basis. There are different considerations if indemnity costs have been sought and awarded. And so in terms of the principles that apply in relation to VAT, and in particular recovering VAT that has been charged in costs, these are set out in the practice direction of the civil procedure rules, in particular practice direction 44, and that is paragraphs 2.1 to 2.14 of that practice direction. So the first case in relation to this, in which it arose, concerned search fees. So in the context of a conveyancing transaction. And the case concerned is called Brabner's LLP and HMRC, 2017 case before the First Tier Tribunal. And the appellant, Brabner's, was a law firm with a real estate department. And it provided conveyancing services to both buyers and sellers of property, both commercial and residential property. And so what it would do is, when it was instructed by a prospective buyer, it would often, not invariably, but often agree to prepare a report to the client advising in relation to property searches that would be undertaken by an agent of the law firm. And there were three ways in relation to which property searches could be undertaken. The first is a search could be made by the local authority using its own employees. And that is normally referred to as a postal search, because traditionally the request to the local authority was made by post. Alternatively, the same search could be personally undertaken by someone from the firm's solicitors or an agent on their behalf by attendance at the local authority's offices. And that is normally referred to as a personal search. And thirdly, it is also possible to conduct an electronic search.